Hello and welcome to insights into the two most popular types of Ptab proceedings, appeals and inter partes reviews, the first of Virtual Patent Gateway's Ptab Practitioner series for 2022. Today's webinar is hosted by Virtual Patent Gateway founder, Ashley Chung. Virtual Patent Gateway was founded in January 2020, right before the pandemic, and Ashley has a passion for supporting Ptab practitioners and is committed to developing a growth mindset within VPG. Joining us today is Joe Piccolo, partner at Davidson, Berquist, Jackson & Gowdy, and Steve McBride, partner at Carmichael IP. Joe is a registered patent attorney focused on Ptab appeals. For more than 28 years, he has represented the PTO in numerous appeals and civil actions, orally arguing 50 Federal Circuit appeals and drafting more than 80 Federal Circuit briefs, as well as acting as co-counsel in more than 60 additional Federal Circuit briefs. He has achieved numerous victories throughout his federal government career. Steve is an experienced patent attorney focused on representing clients in front of the Patent Office for inter partes reviews, re-examinations, and other post-grant proceedings. Over the past decade, he has successfully represented dozens of clients in patent litigations in U.S. district courts, the Federal Circuit, and the International Trade Commission. This webinar will be recorded for future use and available on YouTube following the session. There will be a short Q&A at the end of the presentation. You're welcome to type your questions in the chat throughout the presentation, and we'll address them at the end. And with that, I'll hand things over to Joe.
Thank you, Caitlin. As to questions, it's a good idea to type them in as soon as you have one, because if there are multiple questions at the end or many questions, we'll have to take the earliest ones first. So don't wait. Type them in as you think of them. Ptab appeals are worth it. There are many ways to win during a Ptab appeal. The MPEP sets forth the pre-appeal brief conference way, and that entails that shortly after an examiner's final rejection decision, you can file your notice of appeal with a short argument paper addressing the erroneous rejections by the examiner. You can do that sooner rather than later after the examiner's final rejection decision. And the PTO has informed me that 1/3 of the time, those short argument papers lead to a withdrawal, a removal of the examiner's rejections. 2/3 of the time, the case goes forward, but 1/3 of the time, the inventor wins right then and there in just a few months, it could be. You can file your short argument paper shortly after the examiner's final rejection with a notice of appeal. That's what the pertinent MPEP section says. Many of those cases result in the inventor's favor very early on, and I call that appeal phase 1. The inventor wins in approximately 35 applications out of 100. If you're choosy on your appellate counsel, your chances can improve to 50% plus and higher early at appeal phase 1. After filing a notice of appeal and a short 5-page maximum argument paper, there's also the chance to win right after filing a main brief. So for those 65 out of 100 cases that go forward to the briefing stage right after the main brief, which you can do as soon as you're ready, the inventor wins again 1/3 of the time. The PTO has informed me of that statistic, that the main brief prevails and an examiner's answer is not even filed 1/3 of the time. An examiner's answer is filed in 2/3 of the cases answering a main brief, but 1/3 of the time, the inventor wins right at this stage. That's the MPEP section that talks about how there's conference. There has to be right after the inventor's first brief is filed, and the conferees, including a supervisory patent examiner and another experienced patent examiner, decide whether to defend the examiner's final rejection decision or not. That also is right in the MPEP. So at this phase of an appeal, I call it appeal phase 2, the technology center is deciding whether to file an examiner's answer. So we had the pre-brief phase 1, inventors win 35% of the time. We have this phase, the inventor's main brief is filed, inventors win 35% of the time. The PTO has given me these percentages. So inventors regularly have quick success from contesting an examiner's final rejection decision. Appeal phase 2 just takes one brief, there's no answer, and the inventor in 35% of the cases has quick success. If you, again, choose good appellate counsel, your chances can be increased. It would be good to have more than a 50% chance of success with a very good main brief. When the examiner is allowed to answer and the inventor files a reply brief to the examiner's answer, we are now entering appeal phase 3. And with an examiner's answer and no withdrawal by the Technology Center, the application appeal will be forwarded to the Ptab. The Ptab will now be deciding the case. However, at this phase, examiner decisions get upset a lot. Ptab statistics show that if you look at the bottom left box, on this monthly set of tables that the Ptab sends out, one is for the most recent month, and the bottom table is a fiscal year to date table on statistics. But in the bottom left box, you can see that examiner decisions are affirmed by the Ptab only 55.3% of the time. Appeals to the Ptab are worth it. You can save broad inventor claims. Even at this phase 3, inventors have an even better chance of succeeding, and they could get patent term back through patent term adjustment later on. So as I was saying, with only 55.3% of examiner decisions affirmed by the Ptab, more than 44% of appeals are decided in the inventor's favor. This is phase 3 for Ptab appeals. As with phases 1 and 2, phase 3 includes much success for inventors. Collecting phase 1 plus phase 2 plus phase 3, we can see that during phase 1, with the notice of appeal from the examiner's final rejection decision, out of 100 appeals, inventors win 35 of them. 35 of them. At the next phase, with filing an inventor's main brief, as the PTO states, inventors win again another 35% of those cases. So what's left, 65 appeals after the original 100, a 35% success rate for inventors at phase 2 leads to 23 more wins for the inventor. Then in phase 3, at an even higher winning percentage, another 23 or 18 are won from the 42 left. So really, throughout phases 1, 2, and 3, only 24 appeals did not go in the inventor's favor at either phase 3 with a 44% chance success rate, or phases 2 or 1 with a slightly lower success rate. The overall success rate, starting out with 100 appeals, is 76% that the inventor will win during this track. First 2 phases can be relatively fast because the inventor controls the timetable by filing the short argument paper sooner rather than later, and if needed, turning that paper into a main brief, and again, filing it on the inventor's timetable and putting the pressure on the PTO to not defend the examiner's answer. At phase 3, I think it's not known well enough. That only takes, I have PTO data on this as well, that only takes about a year to have your case decided by the Ptab. And when prevailing, the inventor gets the lost time back. So a noteworthy point is that phase 3 is not as long as a lot of people think. There used to be a big backlog at the Ptab, and pending appeals were in a bad state of near 3 years in terms of average pendency. You all probably know that the PTO has hired many many APJs to handle its workload. The backlog has gone down, and PTO statistics show that Ptab briefed proceedings take about a year for the Ptab to decide, and 44% of them are decided in the inventor's favor. This table summarizes what I've been talking about in terms of phase 1, phase 2, and phase 3, and the windows of time that we are in each of those phases and what the inventor is doing. In phase 1, remember, under my first cited MPEP section, it's a short 5-page maximum argument paper with the notice of appeal. And the supervisor gets involved with the examiner, and in 35% of those cases, the inventor wins. For the 65 out of 100 remaining cases that are not resolved in the inventor's favor during phase 1, phase 2 kicks in, and the inventor, on the inventor's timetable, files the inventor's first brief. And at that point, the PTO conference grows. It grows from 2 PTO officials to 3. And in 35% of cases at that point in time, the Technology Center decides to not prepare and file an examiner's answer. So after phase 1, during phase 2, another 35% of appeals are decided in the inventor's favor. Well, for the 42 appeals left, starting phase 3, we have a very high success rate at the Ptab. And again, that comes from this monthly chart found at this link. It's in the PTO's Ptab statistics area of the PTO website. The winning percentage is often in the 40th percentile of cases decided by the Ptab. And it takes about a year, and of those cases in the inventor's favor, there will be patent term adjustment available for the inventor per Congress. So collecting phases 1, 2, and 3 out of 100 appeals, inventors win 76% of the time. And that's with what's happening now. Shopping around for good appellate counsel can get you in the 80th percentile, I would say, no problem. As I've been discussing, PTO data shows that weak rejections are regularly issued, and the inventor community should not easily amend claims and narrow an inventor's property. Rather, it can be very quick to use the appeals process and the 3 phases I have gone over to stick with the inventor's broader claims. Examiners make many mistakes at the PTO. We see in what I have presented so far, about 76% are upset during the appeal path. Inventors make many mistakes. Do not give in to poor examining. Rather, keep your broad claims, invest in broad claims using the appeal process. Congress gave us this tool. It should be used even more frequently. Do not acquiesce to examiner unreasonable positions. Each month, there are about 10,000 final rejection decisions. However, only hundreds are appealed to the Ptab. Yet, as I've gone over, the examiner error rate is over 76%. Why not appeal many more, or at least put them in phase 1 and see how it goes? You can get quick success by appealing many more of the hundreds that are being appealed to the Ptab. There are 9,000 plus examiner final rejection decisions that could take advantage of the appeal process, phase 1, phase 2, and phase 3. Good results will happen. I've studied this area and these statistics for a long time. I view it as needed due diligence for practitioners to review the prosecution records or retain appellate counsel to review for you and get into phase 1, review with an eye toward appealing. You can keep the broad claims, and it's really needed. I consider it required diligence on the part of a practitioner representing an inventor before the PTO. Scrutinize what happened before. Examiners make many errors. Inventors often win. Due diligence can raise our winning percentages, as I said, hopefully over 80%. It's at 76% now. As I said, Congress already allows for when you win at the Ptab, you will get that time back. There are a statute and a regulation supporting the inventor for this return of property. For phase two, when we're trying to convince the Technology Center to not defend the examiner's final rejection decision, we should try to win our case in the facts section. Early in my career, I had a boss who said, win your case in the facts. That's where you want the reader to agree with you. Use the facts to prevail. So we're going to be very careful with how we write our facts, not overstating. Then the examiner has to concede, because if the examiner contests concrete, irrefutable points, the examiner loses credibility with the Ptab. Focus on our bases of appeal. How are we going to attack the examiner's weak rejections? If it's about something missing from the prior art, highlight that claimed element, and others can just quote the claim. Use the facts to highlight what's coming in the argument section. Rules of law can be teed up in the facts section by how you are going to explain that motivation is lacking, for example, or if our claim construction is the best, and if we have specification support for it, then of course we're going to quote and use that specification passage for our claim construction. Use application drawings. A picture is worth 1,000 words. The board is going to review things anew in light of evidence and arguments. So we are not having to deal with the examiner's findings at this stage. We just have to pick at them and put the examiner in a corner. Again, using things that are irrefutable so that the examiner has to concede. Use argument headings to articulate our points. Don't be terse in argument headings. They can lay the groundwork for what's coming afterward in discussing the facts and rules of law. Use the most recent Federal Circuit cases. That shows the Ptab that we follow Federal Circuit law, and we are very mindful of the tribunal above the Ptab. The Ptab will understand that there is a higher tribunal, and this appellant knows about its most recent case law. That can only help you. Then there are earlier cases you can mate up with your facts. Has the examiner conceded in the examiner answer? So we're into phase three. The examiner and the TC did not decide to withdraw the rejections. They filed an examiner answer. Maybe the examiner conceded. If so, those are great points to mention first and highlight at the beginning of the reply brief. Has the examiner had a theme? We can cover many points by just addressing the theme, and we have to definitely attack the top argued points, attack all argued points, but emphasize our rebuttal to the top ones. Give the APJs a roadmap, and actually there are things that we can agree with the examiner on, so we are narrowing the appeal and crystallizing issues for appeal. At oral argument, the examiner might not be there. However, if the examiner is there, our reply time and points will be critical. Figure out what we're going to say during the Ptab's discussion with the examiner. What is on their minds? Welcome their interruptions. It is their time to figure out who is right and decide the case. Respond with facts and evidence. Don't hypothesize. Don't present things that aren't helpful. Facts and evidence especially, are the most helpful. We owe this to examiners. We have a 76% chance of success rate by appealing. Do not give up so easily. Do not give up. Acceding to examiner error is simply contrary to the inventor's interests. Invest in broad claims by appealing. That's me. And I'll end with the table about how there is much success to be had by appealing. Thank you. Steve.
Thanks, Joe, and thanks very much to Virtual Patent Gateway, Ashley and Caitlin, for inviting me here to speak on IPRs. My name is Steve McBride. I'm a partner at Carmichael IP, handling primarily IPRs and recently quite a few reexaminations as well. Our firm has had a good deal of luck and has been named for 5 years in a row as most successful law firm in the country, representing patent owners in IPRs with a win rate above 90%. Because Joe gave you some statistics about winning, I'm going to start here with some statistics on how to win IPRs and how common that is. And then we're going to move on to how to improve your chance of winning an IPR and conclude by discussing recent developments involving ex parte reexaminations being used as follow-ons to IPRs. Then Joe and I are both going to take questions. First, let's talk about statistics. The board is internally organized according to 4 technical divisions. The first is electrical and computer. The second is mechanical and business method patents. The third is chemical, and the fourth is bio and pharma patents. Administrative patent judges, APJs, are all assigned to one of those divisions. By far, the most popular division for IPRs is electrical and computer. Nearly 2/3 of all IPRs are in the electrical and computer area. Mechanical and business method accounts for about 1/4 of the IPRs, and the chemical and biopharma divisions each have only about 6 or 7% each. We're interested in chances of winning. For the last 5 years, the Ipr institution rate has hovered around 65 to 70% per patent. It's a little lower per petition because a lot of petitions involve the same patent, so it goes a little lower there, but on a per patent basis, it's 65 to 70%. That means most patents challenged in an IPR petition are subject to a patentability trial at the Ptab, assuming you don't settle out or something else like that happens. Only 8% of patent claims receive a final written decision upholding validity. And that sounds pretty bad, but there are a few things to understand here, and one is that only about 1/4 of IPRs actually reach a final written decision. So it's 8% out of 24, 25%, something like that. In addition, there are strategies for getting that win rate closer to 90%, and I'm going to share some of those now. First, to maximize the chances of winning, we need to understand how the Ptab is different than a district court. Obviously, a district court is an Article 3 court, and the Ptab is an administrative proceeding, so there are procedural differences you'll need to be aware of, but there are much more bigger picture important differences as well. First, APJs are not swayed by thematic arguments like might be useful in a jury trial. Instead, APJs need technically focused arguments that are backed up by evidence. Basically, if a lawyer fails to back up every argument in an IPR with precise and detailed technical evidence, the APJ could view it as a waste of time and a weak argument and use it as a basis to lose the IPR. Another difference is that in district court, the first phase of a case is discovery, where the parties are disclosing information and developing and changing their legal theories. In an IPR, you only have one chance to say what needs to be said. The proceeding starts with the petition. There's no discovery, and the petition itself is really a trial on the papers, not a preliminary phase where parties can develop evidence and shift theories later. So all the evidence you put forward needs to be in the petition from the start. It's going to be difficult to add evidence and theories later on, and you maybe have to get a little luck in order to do so. Another difference is that both district courts and Ptab proceedings involve expert depositions, but there are meaningful distinctions in the depositions in the two forums. Depositions in district court are primarily discovery. There are other goals depending on the deposition in terms of what you're looking to do. You might try to box in an expert for trial, but they're primarily a discovery tool. In the Ptab, IPR depositions are not depositions at all in the traditional sense. Instead, they are more equivalent to the trial cross-examination. But the big difference here is that the APJs themselves are never actually going to see the expert. They're never going to see the witness testify unless something unusual happens where they have to review the deposition video, if there is any. As a result, if a witness is totally evasive, dodgy, and uncooperative in an IPR, that doesn't really come across on a transcript like it would in a district court trial. So all this calls for a very different approach to IPR depositions, including how to prepare witnesses and how to conduct the examination. A further difference is the judges between district court judges and APJs. In a district court, there's only one judge, and you know who it is from the beginning. You might even know who it's going to be before you file your case, depending on the forum. At the Ptab, there are 3 judges, but there are some differences. First, they are not typically identified to the parties before the initial papers are filed. So you may not know who the judges assigned to your case are for quite a while in an IPR. One trick that may allow you to discover that relatively early on is by filing a motion for pro hoc vice of a lawyer who is not a registered patent attorney. That requires an order from the Ptab, and the judge. The judges on the case will usually be identified in that order. And while there are 3 judges assigned, there's only one number 1 judge. There's only one lead judge. The PTO doesn't publicize this, but one of the 3 judges is always assigned to be the lead judge. The number 1 judge, the lead judge, studies the record in detail and discusses it with the number 2 judge. The lead judge is expected to write the decision, but only the lead judge gets any production credit except in the rare case of a substantial dissent. In my experience, the lead judge usually does far more work on a case than the number 2 judge, and the number 3 judge does even less. Therefore, the number 1 judge has great influence over the IPR, even though it's a secret who the lead judge may be. So one goal heading into an IPR, aside from identifying the judges themselves, is to identify who the lead judge is and try to tailor your arguments to that judge accordingly. Further distinction is the burden of proof. In district court, it can be very hard to prove invalidity, and that's because the challenger has to prove invalidity by clear and convincing evidence, which is a fairly high burden of proof, and they must persuade a finder of fact that is likely to defer somewhat to the examiner's determination that the invention is patentable. Judges and juries, especially, often defer to the fact that the patent has already been granted and has already been reviewed by the patent office as a kind of a thumb on the scale against a finding of invalidity. In an IPR, the challenger only needs to prove unpatentability by a preponderance of the evidence, and the APJs don't defer to the issue to the issued patent or to the fact that the examiner has already allowed it. So putting this all together, the Ptab is generally a much better forum to challenge a patent over prior art printed patents and publications than the district court, and these differences must be kept in mind to maximize your chances of winning at the Ptab. Now I'll give you some tips for winning the IPRs themselves. First, you need to have support for every claim term in the petition. So a patent owner's attorney should take a hard look at every word of every claim, even if it seems trivial at first. The petitioner is stuck with what is included in the petition. The petition must point out where specifically in the prior art every limitation can be found. And a failure of proof on this, even sometimes on relative technicalities, can lead to findings of patentability. The same issue goes for obviousness. If there aren't clearly explained rationales for combining references in the petition, that can sometimes sink IPRs. So pay attention to that for the petitioner. Make sure you've covered all elements that have a combination. Make sure you've covered it with a motivation to combine or a rationale and reasonable expectation for success. And for patent owners, make sure you look for every element that requires a combination, that there is a corresponding rationale for combining the references. A further difference is dependent claims. The APJs will pay attention to the dependent claim arguments. So patent owners should evaluate whether the petition has glossed over certain dependent claims that have good infringement reads and focus some arguments on those as well. Another tip for both sides is to work closely with litigation counsel. IPR attorneys for both sides have to work closely with litigation counsel every step of the way to make sure that arguments for claim construction and patentability in the IPR, for example, do not unduly box in the district court case. Further tip is to consult with a technical expert. Because the APJs are a relatively technical audience compared to a district court, guidance from the experts can be much more useful. I've found that experts tend to have a lot more helpful input in terms of explaining how the prior art works and motivations to combine and things like that at the Ptab. One idea that we have here is to try to hire, whether as the testifying expert or just a consultant, authors of cited prior art references, because they tend to know the lay of the land pretty well with respect to the prior art. Another tip is, before taking expert depositions, both parties should research patents and publications of the opponent's experts, or find some other way to get them talking in an unscripted manner during the cross-examination. Because otherwise, unlike a district court trial, experts can really stonewall relatively easily in an IPR. You want to get the expert away from relying on his declaration as much as possible, because a well-prepared expert will most likely simply rely on the declaration and not go past the four corners of that. So getting creative ways to bring up issues in ways that the expert doesn't immediately rely on his declaration can be helpful in IPR depositions. One great approach for petitioners, and patent owners can do this in their briefing too, but is to include annotated prior art drawings in color to show how the combination would result in the claimed invention, or conversely to show missing limitations. And this is helpful because before the hearing, the number one judge will review the papers, and it will obviously help the number one judge to understand the arguments being made and how the prior art functions. But the number one judge will also explain the case to the number two judge, and often by referencing the prior art drawings and challenge claims. So if there are annotated versions that explain it simply, and a lot of times this is simply taking what the specification says about the figure that best embodies the invention of the prior art, that can make it pretty easy for the judges to see it your way. Another tip is that petitioners have the burden of proof, and so should avoid relying on conclusory statements of experts. A district court may adopt an expert's opinion if it sounds reasonable, but the Ptab is going to take a closer look and require more detailed evidence and reasoning backing up every single opinion with respect to every single limitation. Some arguments that tend to have a good chance of winning for a patent owner are where a claim element is completely missing from the asserted prior art combination. This is a sort of failure of proof argument, but it can be more compelling at the Ptab because the Ptab is going to look very closely at every single limitation, and sometimes even omissions that are relatively technical can be persuasive. And a second area that patent owners often have a good shot of winning at the Ptab on is whether a reference actually can be proven to be prior art in the petition. This generally applies to printed publications, not patents or published applications, which are easier to prove publication. But for printed publications, it can be anything from a textbook or a proceeding from a standard setting organization, documents that are presented there. There are more exacting standards relying on the federal rules of evidence for establishing that these documents are prior art. So that's one way to attack a petition for a patent owner, and it's something that's can be relatively have a relatively high success rate. Equally important for patent owners is avoiding arguments that tend to lose at the Ptab. And here are 4 arguments that are popular with patent owners, but often lose at the Ptab. Teaching away. This has got to be a really strong teaching away in order to win a lot of times. It can't be ambiguous or kind of a mixed message. It has to be very strong that the prior art wouldn't incorporate certain elements of a secondary reference or something like that. Non-analogous art is similar. It has to be really strong that the Ptab will look a little more broadly in terms of what is analogous art. So it has to be a very strong argument in order to be successful usually. A lot of patent owners will attack references individually instead of dealing with the combination. That is, focusing on what one reference in a prior art combination doesn't teach, instead of focusing on what the combination as a whole does teach. In my experience, this is a place where petitioners have a little bit more flexibility, that it may be technically that the prior one prior reference doesn't teach a certain limitation, but if the other prior reference teaches it and you've described it in detail in the petition, a lot of times you can make the argument that's what you're relying on for the specific part of the limitation and issue. And a final area that is often a loser at the Ptab is arguing that the inoperability of bodily incorporating one prior art system into another. Another point is the Ptab in general is more open than the district court judges or juries to combining multiple references for invalidity. So whereas in the district court, I like to ideally have an anticipatory reference, and if not, one reference, two combination reference, prior art ground at most. In the Ptab, it's not uncommon to see 3 or even 4 pieces of prior art used in successful grounds. One tip for oral argument is to avoid putting the entire argument in demonstratives. Ptab rules require that the parties to exchange demonstratives a week before the oral argument. Most attorneys will put a lot of effort into the demonstratives, and this gives away a lot of arguments to opposing counsel effectively a week in advance of the hearing. I prefer to only include demonstratives that the opposing party knows will be part of the discussion. The APJs have easy access to all parts of the record during oral argument, and we can direct them as attorneys to what we want them to look at, which we need to state on the record anyway. That being said, because demonstratives are visual, the best demonstratives are often copies of annotated drawings from the briefs with no additional explanatory headings. The final thing I want to touch on before we move on to questions is some recent developments in IPRs, and especially involving ex parte re-examination. One thing that's been seen recently is that a lot of times if an IPR is unsuccessful, the petitioner will turn around and file an ex parte re-examination on similar or the same grounds. There have been a lot more of those recently, and I want to touch on that just a bit. Statistically, there's very little chance that a re-examination request will be refused by the PTO. In the last full year statistics, only about 6% of ex parte re-examination requests were denied. The most recent quarter for which statistics are available, the first quarter of 2021, had 46 orders granting re-examination and 0 orders denying re-examination. So 46 granting, 0 denying. When you have a rate like 100% of re-examinations being requested, accused infringers perceive very little risk in filing the re-examination request. And at the very least, a defendant in a litigation can inform the court that the PTO has found a substantial new question of patentability and ask the court for a stay of the litigation, even though there is no time limit for the PTO to complete a re-examination. There's been a perception, well, while I've been practicing anyway, that ex parte re-examination procedures favor patent owners, but the statistics don't really bear this out. Only about 20% of patents survive ex parte re-examinations with all claims intact. That's much higher if you include claim amendments, which more than 2/3 of patent owners eventually amend claims in ex parte re-examination. But obviously, if a patent is in litigation, that is not the most desirable result usually, because amending a claim will generally cut off past damages. So if past damages are at issue, a patent owner wants to avoid amending those claims as much as possible. Because we are seeing a spike in the filing of re-examinations, it's important to learn how to win at ex parte re-examination, which itself is quite different than litigation, IPRs, and regular patent prosecution. It has its own unique procedure with its own peculiar tricks and traps. One note to mention is that the PTO recently installed the former chief judge of the Ptab as the head of the central re-examination unit. This is Chief Judge Rushke, and whether he makes the CRU more like the Ptab is something we're keeping an eye on, is yet to be seen. The final thing I wanted to touch on with re-examinations is the In Re Vivint case. In September, the Federal Circuit issued In Re Vivint, where it faulted the PTO for granting a re-examination request similar to a previously denied IPR petition, under circumstances where the IPR itself had been denied as an abusive serial challenge under 35 USC 325D, essentially saying that for the Ptab to grant a re-examination where the Ptab had already denied a previous IPR as abusive was abuse of discretion on the part of the re-examination unit. The Federal Circuit took pains to say the holding was limited and narrow, but many patent owners will be attempting to use Vivint going forward to fight off re-exams filed after unsuccessful IPRs. This is an area where we're participating in it and watching very closely, and it'll be interesting to see how that turns out. With that, I think that ends my portion of the presentation, and we can turn to questions. And Joe, I see there are a few that look like they are for you.
Thanks, Steve. Very good. First question is about where to emphasize the facts to get your brief rolling factually. And in the summary of invention section, that's a great section to win with the facts. Again, as I said in my slides, what your case is going to be about on appeal can be laid as a foundation in the facts section. Which element is more important and has to be addressed in the argument section, specifications, supporting language, drawings, those types of things, of course, in the summary of invention section. And then in the introduction to the argument section, you can start to pare down. You can pare down what you were emphasizing in the facts section and start to apply rules of law to those facts to show how you prevail. So you're really plucking out of the summary of invention section things needed to be introduced to the argument section. If it's claim construction, the pertinent specification language, more tersely though. So both places are a good opportunity to win with the facts, and your brief is like a funnel. It starts off really broad in terms of information and narrows into the argument. So you are narrowing the appeal for the APJs to decide. There's one more, and then Steve, I'm going to ask you a question, but there's a question about the reply brief that if the examiner in the answer ignored, which is not uncommon, ignored important points made in the main brief, yes, highlight such ignoring, and you can treat them as concessions since the examiner did not contest points made in the main brief. They're not contested. So highlight those really early on in the reply brief, and that's a good way to get your reply brief rolling. And remember, you already argued important points in the main brief, so for the rest of your reply brief, you may just need to have to refer back to broader sections in your main brief, and that saves reading time and gets the APJs focused. Steve, when AIA was first being applied, I think conventional wisdom was that district court cases would be stayed for IPRs, and we saw that number drop down. That wasn't the case during the first chunk of years of IPRs. What have you seen in recent years, and does the strategy change from when there's a stay to when the district court decides to proceed?
In recent years, obviously the Western District of Texas, Judge Albright scheduling orders are designed to conclude trial before the IPR reaches a final written decision. So he almost never will grant a stay. So given that that's the majority of the cases now being filed, or a large percentage of the cases now being filed in district court, and what I do, which is electronics and computers, there it's really very difficult to get a stay unless it's agreed to by the parties. So that certainly has driven the percentages down. I think that other than that, you need to look at the particular district court you're in, and it can be kind of a district by district and judge by judge decision based on when and how they want to grant a stay. Usually it's going to be depend on concessions that the defendant can make in district court, and regarding estoppel, for example, and oftentimes it won't be until you get the institution decision in the IPR as well. And I think there was a second part of your question about, I don't know if I addressed that. It was changes. How does that affect
strategies when there's a stay versus if you have to compete with the district court proceeding in terms of how the merits are being decided, the IPR strategy?
Oh, the IPR strategy in terms of that. Well, I mean, the IPR statutorily, it's got to end a year after institution, except in some exceptional circumstances. So obviously, if it's to your advantage to get the IPR concluded as a petitioner or defendant in litigation, you will want to try to delay the district court as much as possible and seek a stay if you can. Certain district courts are not, but it's not really a starter. It's not really worth asking for that. But there's still things you can do in the litigation, like seeking to file for a transfer, motions to dismiss, things like that, that can extend the district court proceeding a little bit and give you a little better chance to get to the finish line.
Thank you.
Thank you.
Ashley, anything else?
Yep. Thank you so much for participating. Actually speaking for us on the very first webinar this year. And so thank you, Joe. Thank you, Steve, and thank you to all the attendees. We do have a couple more questions that were sent in directly to me, so I'm going to read off. The first one is from Steve Olson, and what he wanted to ask, I think this is to Joe, is he wanted to know your win data, is it for all appeal claims or any appeal claim?
Say the first part again. I didn't hear the question.
So Steve wanted to know, Olson, not McBride. Steve wanted to know if your win data is for all appeal claims or any appeal claim. If I butcher, Steve, feel free to speak.
Well, most decisions are decided in full, not in part. Applications can be segmented out, but to get the case back to prosecution reopened, all rejections withdrawn, the PTO has statistics that all of those are in the bucket of success for the inventor. So a win in hopefully the most important part of the case, the one that has the merits supporting the inventor's position the most, results in success for the inventor. But the cases in part that are decided in part are still considered a win. And maybe the other claims that are still rejected in part aren't as important. So hopefully the win really assisted the inventor along the way. And that's how the PTO keeps its statistics.
Does anyone else have questions? Feel free to ask. I mean, speak up. I guess you guys did it perfectly.
We answered all the questions out there.
Yep, exactly.
So great job.
Great way to start the new year.
All right.
I think, Laura, do you have any questions? No? Okay. Well, I guess we are right on time. Thank you so much. Start us off, right on the, the beginning of the 2022. And we will, this one has no CLE, but we will do our editing of the video and then we'll post it on YouTube once we get like approval from the speakers. And thank you again for joining and thank you for supporting VPG. Have a great rest of the day. Bye-bye.
Thanks, everyone. Happy New Year.